can the case be heard in a federal court? Starting off with that section, Rosemary, can you please tell me what is the second level for this section?
Yes, it's subject matter jurisdiction, removal, and remand.
Subject matter jurisdiction, removal. As I get started with this section, what is your comfort level? When you see these topics, are you like, uh-oh, here we go? Or you're like, oh no, I got a good grasp for those concepts?
I feel like I have a good grasp of subject matter jurisdiction, but then remand and removal, I know I struggled with it specifically on the MBE. Really bad. Yeah.
All right, so we're going to get to some of those detailed rules on where they try to get you on removal and remand. I want you guys also to know that in your practice phase of Civ Pro, just so you guys can understand the lay of the land, that Civ Pro is so recent on the list of MBE tested topics, you really don't have a lot of bar released questions for Civ Pro compared to all the other classes that you have years of history with and years of released questions. So what does that mean? You come across a lot of created questions to prepare you. So just understand the nature of the beast, that this is recently something added to the MBE. Not too many California bar exam or MBE, released MBE questions. So a lot of the adaptive bars, big box companies, etc., they're making questions based off of like what direction they've given, but not a lot have been released. So just keep that in mind. All right. So we need to learn, first off, subject matter jurisdiction. This is the big boy here, right? From a big picture, why are we talking about these three under this subject? Well, this is the main determination for determining if a case can be heard in a federal court. Now, these are related topics that also fall under this umbrella. Removal and remand are essentially about the function of taking a course into federal court, which is removal. If it was initially filed in state, you're going to remove it to federal. And remand it's the inverse of that. It's pushing it back down to the state. So these are kind of like, go together. They're the flip side of the coin. And you're going to learn the rules around when you can remove it to a federal court, or no, it can't be here, so we need to remand it to a state court. All right, but first off, the general rule, subject matter jurisdiction. All right, a case may only be heard in federal court if the federal court has jurisdiction to hear the particular claim. A federal court has jurisdiction to hear the claim under three possible theories. Rosemary, looking at that blueprint, what are those three possible theories?
Federal question jurisdiction, diversity, and supplemental jurisdiction.
Exactly. All right, and then you have supplemental. Now, you guys have a chart, and as you'll see in your chart for this, the way I actually have it down is that you have two main doors and one back door. All right, these are your two main doors into federal court. When you're looking to satisfy subject matter jurisdiction, you start with the discussion of these two. If and when the case that you're dealing with cannot come in under federal question or diversity, then that's when you're going to see if you can come in through the back door through supplemental jurisdiction. Okay? So that's the big picture concept there. Now we just need to learn how cases come in under each of these. Federal question is first. This one is straightforward and simple. Let's go ahead and read it. Federal jurisdiction is met when the lawsuit arises under federal law, the U.S. Constitution, federal law, treatises, etc. Okay? And then we also have the well-pleaded complaint rule here. So basically what this well-pleaded complaint rule is saying is that in order to fall under federal question, the federal law at hand to take this into federal court must be in the plaintiff's complaint. right? But if there's no federal law in the plaintiff's complaint, but only in the defendant's defense, that is not enough to get into federal court under federal question jurisdiction. All right, so let's get to our first quick hypos of the day. Let's go with Arpy. Arpy, you got those hypos ready?
I sure do.
Awesome. Well, I can still hear the cold in the voice, the waking up. We're going to get you some coffee. I know it's Monday morning.
Ani and I were rereading the con blueprint a few days ago, and so I think my throat's just been strained since then.
From all those con law rules.
Yeah.
Yeah.
I'm ready to go.
Let's do it. All right, so go ahead and read number 1 for me, please.
Okay. So plaintiff sues defendant for breach of contract. Is subject matter jurisdiction satisfied by federal question?
So quick question, quick answer. What you think here?
No.
And why is that?
Is it because it's not deriving from federal law?
Exactly. This is state law. So something to get prepared for, guys. On a lot of these Civ Pro questions, they're testing on contracts as the underlying claim. Contract law is state law. There is no federal law. All right. So when you're doing these quick analysis, because a lot of times on an essay, it'll be diversity that you're going to be focused on, but you do a quick heading for federal question, and you're going to say here the claim falls on contract law. Contract law is state law. Therefore, there is no federal question. All right. Arpy, go ahead. Read 2 real quick for me.
Okay. Plaintiff sues defendant for negligence. Is subject matter jurisdiction satisfied by a federal question?
All right, so here we have negligence. Negligence falls within what class, Arpy?
Torts.
Torts. Do you think torts is state law or federal law?
State.
State law. Boom. Same question, different law, but it's still state law, so therefore no federal question. So note to self, guys, really quick when you're going through these analysis, if your underlying claim is contracts or torts, then there is no federal question. All right, 3, I'll read it, you answer. P sues D for defamation, and D asserts the affirmative defense of the First Amendment freedom of speech. Is there subject matter jurisdiction based on federal question here, Arpy?
So defamation, torts, no, state law?
Exactly. What Arpy did not fall for was that you did have federal law at hand here. You did have federal law in your defense, but that violates the well-pleaded complaint rule. So very simple concept. Do not just squirrel, right? I see federal law. You have to see where it's at. You have to see that it is in the defense, not in the complaint. All right, number 4, back to Rosemary. P sues D for First Amendment freedom of religion violation. Do we have federal question jurisdiction here?
Yes.
Perfect. That's from the Constitution, right? First Amendment freedom of religion. Interpretation of the Constitution will be federal law. We do have federal question jurisdiction. Last, P sues D for copyright infringement. Do we have federal question there?
Yes.
Good. And we just have to remember that copyright is federal law. Can you point to something? Can you remind me where copyright fell within our con law? So we're mixing in our con law questions since we didn't do our game this morning. Can you tell me where copyright fell in con law?
Copyright fell. Wouldn't it be?
Lost that one?
Freedom of.
Let me stop you there. There's definitely no freedoms involved. Yep. Any volunteer on that real quick before I give it to you guys? Mark?
Legislative branch. Congress.
Well, that's nice. Yeah, legislative branch. All right, thanks, Mark. Go all the way down. Legislative branch.
The enumerated powers of Congress.
Exactly. Legislative branch. Power to pass the law. Then under that, you had Congress versus state. We're in Congress. Congress source of power. Then under Congress source of power, Commerce Clause, taxing, spending, amendments, other category. And in the other category, there was copyright, coin, all these different things. So good, just a little refresher there. But copyright is federal law, which is why in this Civ Pro question, federal question jurisdiction is satisfied. All right, back to the blueprint. So we're out of federal question jurisdiction. Pretty straightforward. You had your general rule and you had your well pleaded complaint rule. Mark, let's go ahead and walk through diversity of citizenship together, okay? What is the function of the rules we're about to learn? Let's make sure we're grounded here.
The function is to allow citizens of different states to sue each other.
Okay, and then that's kind of getting into the heart of it. I was looking for just a bit up, and that the function of this is being one of three ways to satisfy subject matter jurisdiction. But you're right as far as the essence of it. And so let's just remember, this is another way to satisfy SMJ. Now here, we have two elements, right? We have elements that we didn't have before. We have elements now. What are the two elements to satisfy diversity of citizenship?
You need complete diversity and satisfy the amount of controversy.
Exactly. Do we have any other sections from that note from that level? So there's just two things: the complete diversity requirement and the amount in controversy. All right. Now, complete diversity, we have our general rule. As Mark said, right, the essence of diversity cases are when you're dealing with parties from different states. All right. So you have somebody from California suing somebody from New York, right? Now, what happens is sometimes they will tell you the citizenship of the parties, but other times they won't. And before we get into figuring out citizenship, let's get into what the rule actually requires. Every plaintiff must be of different citizenship than each defendant. All right? Each plaintiff is of different citizenship than each defendant. So, if I told you, Mark, you had plaintiff from California versus defendant one from Texas, is that going to be complete diversity?
Yes.
Now, what if they happen to be suing two people and defendant two was from California? Is that going to still be complete diversity since you still have these two?
Yes.
No, general rule. Each plaintiff must be of different citizenship than each defendant. So let's go ahead and make sure we're taking that in now, guys, that here by adding the second defendant that had the same citizenship as the plaintiff will destroy diversity of citizenship. So you have to have it where each plaintiff is of different citizenship than each defendant, right? There's going to be some like little different exceptions we're going to see along the way, right? Things like that. But that is your general rule. Okay? Now, after you go through that general rule, this is again where I'm telling you there are times in your MBEs and essays where they simply tell you plaintiff is from California or from state X, the defendant is from state Y, etc. But then there are times where you have to figure out what is the citizenship of each party. All right. So when getting into the figuring it out, we break down the rules between citizenship of a person and citizenship of a corporation. Okay. So can we go with Yadi? Yadi, can you tell me what the rule is for determining citizenship of a person?
A person's citizenship is determined by their domicile. A person is domiciled in the state in which the person is physically present in and has the intent to remain. A person may only be domiciled of one state at a time. Note, if a person is physically present in a state but does not have the intent to remain there, then chances are he is a citizen of the state he lived in prior to his move.
Boom, there we go. We got two elements, and one important takeaway is something novel about person is that you can only be a citizen of one place at a time. All right. Now let's go into citizenship of a corporation. Don't read the note there. I'll skim over that. Just go ahead and read the general rule and the two bullet points.
A corporation is a citizen of any and all states of incorporation plus their one principal place of business. Thus, the corporation may be a citizen of more than one state. State of incorporation and place and principal place of business, the new nerve center test. A corporation's principal place of business is wherever their corporation activities are coordinated, typically the state in which the headquarters is located.
All right, make sure you're seeing what that rule for principal place of business actually requires. Now, quick question there, Yadi. Can a business be a citizen of more than one state?
Yes.
Can they have multiple states of incorporation?
Yes.
Good. Can they have multiple principal places of business?
No.
Exactly. You can only have one principal place of business, but in addition to that, you can have one or more states of incorporation. So therefore, you could have, right, 3, 4, 5, right, different citizenships for one corporation. But again, it's going to get more numerous from the states of incorporation, but you can only have one principal place of business. It's not principles, places of business. It's principal place of business. Okay, the note there on the other page is for the rarely tested unincorporated business, such as an LLC, and then it tells you like a little sub rule for that, but you guys can deal with that later. Rarely tested. You also have the exception for the cases involving aliens. I actually want you guys to make a little edit for just to have this rule read better. There's nothing that's wrong here, but the way it's worded might leave you a little confused. So it says, even if each plaintiff is fully diverse from each defendant, a federal court will not have subject matter jurisdiction if, and then I want you to cross out starting with both and then up until U.S. citizens. So cross out both the plaintiff and the defendant are aliens, and so cross that point out, and just then it reads a little bit easier that the federal court will not have subject matter jurisdiction if U.S. citizens are not present on both sides of the action. Okay. So we'll see that here in an example shortly. You can see the July 2016 exam for this exception. And then you have a rule for class action suits, right? You guys can go through that one. Rarely tested, but threw it in there just for you to have it. All right. Let's go ahead and jump to our hypos now. All right. So again, we're going to kind of go with a bit of a momentum and speed with subject matter jurisdiction. So I know we're going fast. If you have questions, definitely write them down. You can ask them at the end of class or the breaks. But this is a little bit more straightforward on the Civ Pro topic. So we want to keep a pace here. All right, so we're reading diversity of citizenship. We have number 1, okay? So I'll read this question. This one's going to be for, let's go with Shavi. Shavi, here we go. Renee is a high school senior who lives in California, right on the state line adjacent to Nevada. After living in California her entire life, she decides to leave California and go to Howard University in Washington, D.C. for college. She's not a big fan of D.C., but decides to finish out her undergraduate studies there because she's getting great life experience by living in another state. It's now her senior year in college, and she attends a school job fair. At this job fair, she is offered a job by a recruiter for surf instructors in Hawaii. This job requires an indefinite commitment of living and working in Hawaii. This is not a problem for Renee, as she has always wanted to live in Hawaii. She accepts the job offer at the job fair. What is Renee's citizenship? This was modeled after my life. I wanted to move to Hawaii. All right, so what is Renee's citizenship? Shavi, California, Nevada, Washington, D.C., and or Hawaii.
I'm going to say California.
All right. So let's go through this. We remember that when we're talking about citizenship in a question like this, you have to have a starting point. What's your starting point, Shavi?
That she lives in California right now. Well, before going to college, she lived in California.
Exactly. So your starting point is essentially where they're born, where they lived first, right, etc. So you have to always start with where their citizenship is and was. And then your perspective and your mindset is, where the two elements ever met for any other state for it to then change to another state. All right. So your default was California there. All right. And so then you can look into, first off, it asks about Nevada, right? Is there any chance Nevada is going to be her domicile? No. There's no physical presence in Nevada or intent to remain there. It simply said that she lives on the state line adjacent to Nevada. Well, then what about Washington, D.C.? Well, Washington, D.C. had one element, but not both. She was physically present in Washington, D.C. However, she never had the intent to remain there. It said she's not a big fan of D.C., but wants to finish out her undergraduate studies there. She went to D.C. not to move there permanently at any point. She went there for the sole purpose of attending college, right? But she had no intent to remain there past that. All right, so there would be an argument there of no intent to remain, so no domicile for Washington, D.C. Then next, you had Hawaii. Hawaii flipped it. You still had one element there and one element missing, but now it was the physical presence that's missing in Hawaii. But the facts do tell us that there is an intent to remain there indefinitely. So under these facts, Renee would become a citizen of Hawaii when, Shavi?
When she moved there, when she was physically present
As
there.
soon as she touched down, right? She had her Mai Tai off the plane, her new little lei they put on you when you get off. It's the best. We should all move to Hawaii, guys. Let's start a village out there. Okay. Number 2. Let's go with Max. Max, Heidi is a California citizen, born and raised in Los Angeles, California. On the playground is where she spent most of her days. She is currently a 3L at Legally Fit Law School. She attends a job fair and accepts a job at a law firm in Nevada. Okay. She then goes on to take and pass the California and Nevada bar exams. She's now ready to move to Nevada to start her new job. She rents out her home in Los Angeles and moves to Nevada. She took all of her personal belongings with her to Nevada. All right. What is Heidi's citizenship? California and or Nevada?
Well, I think it could go either way because I think there's an argument to be made on each side. Because one, she is physically present in Nevada, but we don't know if she's going to stay there because she did take both the California and Nevada bar exams. But she did accept the law firm position there.
Okay.
So
Keep going. You got to, right? Make it juicy, like Matt said. Get all those points. So what other facts can you analyze and argue as to why? There's a few more. Or I think just one more.
She has all of her personal belongings out in Nevada. But in terms of California, she didn't sell her house. She's only renting it out. So that could mean that she may want to come back out there.
Good. She took the California bar exam, which shows that she may have intent to come back to California and practice there. Right? And then you could just make the final, just kind of overarching argument. She's from California, and there are no conclusive facts that she plans to remain in Nevada. All right, so first off, what was of most importance is before even getting in, Max, you understood what type of question this was. One that is not very important with the conclusion. It's not focused on the conclusion, it's focused on the argument. So that's right, the main lesson out of that one. So great job. And then you went in there and saw some of the things to argue. So some things to take note of, because this is modeled after something you'll see with this whole like taking a job somewhere else, right? Did they move all their belongings to a new state? Did they keep their home in the original state? Did they rent it? And then what's the anticipated duration of working in the new state? That was one that you could have added, Max, in favor of Nevada, that she went there and took a job of being a lawyer, which has an anticipated duration of a long period of time. So a little bit more than suggestive that she does have intent to remain there, as opposed to her having like a gig in Nevada for a very brief stint, right? If you can kind of like dive into those facts. Obviously, they're not the most conclusive, but we're looking to see what are the typical arguments in this type of question. Okay? So, good. All about the arguments, not the conclusion. Great hypo. I would likely say California because that's where she started, and maybe there wasn't enough, but you could definitely go ahead and conclude Nevada if you thought there was enough there. Who you repping today, Max? What's the team on the jersey?
It's Russia.
Russia.
It's the Euros in soccer.
Yeah, it's a crazy time for the soccer fans. Okay.
Oh, it is crazy. Yes.
Who's just give me like who's the top team looking like right now?
there's a lot. Italy's looking really good right now. England's looking good.
Okay.
It'll be interesting to see what happens. Yeah.
All right. I want to make sure though, should nobody be looking better than Conlaw and Civ Pro? We better stay focused, okay? Euro.
100%.
There we go.
100%.
That's what I'm talking about. I remember, guys, just a quick little backstory. When I was studying for the bar, it was the World Cup in Brazil, which was one of the like poppin' World Cups and crazy for soccer. And oh my God, like literally we would be in lecture and people would be like streaming the games. Hope that's not you right now because ain't nobody in class to call you out. But people would be streaming the game, and then one time somebody like was loading in but didn't turn their volume off. So we're just like watching a video on freaking Conlaw, and then in the back you're just like goal, and it's like what the hell is going on back there? Wasn't a good look. All right, so let's go to number 3. Shane, I want to go with you on this one. If I remember correctly, in early bar prep, we might have struggled with this one a little bit. So let's see if we've tightened it up. Legally Fit is a corporation that provides products and services to law students to help them perform well in law school. Legally Fit is incorporated in California. Legally Fit advertises in Nevada through billboards, newspapers, and bus stop ads. Legally Fit has the company policy of traveling to their students so that they get the ultimate convenient experience. Legally Fit tutors 100 students a week, and 90% of Legally Fit's clients are students who attend law school in Nevada. Per company policy, Legally Fit tutors travel to Nevada for every session with a Nevada student. Legally Fit's president and secretary are located at the headquarters office in California. This office's location is right on the state line of California and Nevada. Shane, can you please tell me what is Legally Fit's citizenship? California and or Nevada.
Alright, so I think I remember this one. The rule is principal place of business and state of incorporation. So it's incorporated in California, and then its principal place of business is California because it says the secretary and president are in California, so therefore it's California.
Exactly, guys. Only California there. And so let me kind of do a quick little walkthrough for those that may have gotten tripped up here. Now, what this fact pattern does is throw out the bait, right, of giving you all of these facts as to why Legally Fit has so much presence in Nevada. They do so much business there. They advertise there, etc. However, you're not looking at a layman definition of principal place of business. Principal place of business, as defined, is where is their headquarters? Where is the nerve center? What's the like source of all the things they do? So it's typically the headquarters office, which it clearly says is in California. So when it comes to determining citizenship, it is of no effect that you have all of these facts around how much business they do there. Okay, Shane, we remember that if we were to also be analyzing what other topic, that's where all those facts would go of business in Nevada, advertise there, travel there. That's going to be facts for what discussion?
Unincorporated?
That's no, not at all. That's going to be facts for personal jurisdiction.
Oh,
so if later Legally Fit is sued in Nevada, they're going to say, well, how do we have jurisdiction in Nevada federal court? I don't think we do. I don't think there's any personal jurisdiction, right? The plaintiff is going to say, yeah, there is personal jurisdiction in Nevada for all of these reasons, all right? You basically feel at home there. You're there all the time, so you can hear this lawsuit there. So we'll get into understanding that later, but do know that all of those facts go there, but they're designed to throw you off for your subject matter jurisdiction. Okay, so we have California. So let's go to number 4 really quickly. Can you read that fact pattern for me, Shane?
Paul is a citizen of Mexico and is in State B for a spring break vacation.
Woohoo!
Austin is a driver for UPS, a delivery company, and is a citizen of State B. While in State B, Paul is hit by Austin, who was delivering and driving packages. Paul is now suing UPS and Austin for negligence. UPS is incorporated and headquartered in Canada. Is complete diversity helping met.
Okay, where's Austin?
Austin is, oh, so he's for UPS, and UPS is in Canada, so it's a,
No, Austin is a citizen of State B. That's what I was looking for. Where's Austin a citizen of? So you have Paul from Mexico, UPS, Canada, and then Austin, State B. Quick feel. Shane, go ahead, look up. Don't read anything else. What's your quick feel? Is this going to be diversity of citizenship? Quick gut feeling. What you think?
I think no, because there's a foreign party.
Okay, so let's go ahead and look at that rule that we had just read a second ago and I had you modify. Even if each plaintiff is fully diverse from each defendant, here there is full diversity. A federal court will not have subject matter jurisdiction if U.S. citizens are not present on both sides of the action. So, do you have any U.S. citizenship on the plaintiff side here? No. The only citizenship that you have there is Mexico. That is a foreign country. So, therefore, we do not have complete diversity per that little small rule. Now, if it was P1 from Mexico and inside Paul's car was also Cindy from State C, right? Cindy from State C. Oh, based off of that, we'll just do that one time. Then there you would have a U.S. citizen on both sides, and each plaintiff is of different citizenship than each defendant. Okay, so pretty straightforward there, nothing complicated. Just remember that rule regarding aliens. You got to have a U.S. citizen on both sides. Okay? All right. Any questions on that, Shane, or pretty straightforward?
So wait, for the, you said if there was a U.S. citizen in Paul's car?
Exactly, and that was also now a plaintiff as well. That was a U.S. citizen.
And then, so then diversity would be met in that case?
Exactly. Because you have a U.S. citizen from State C here, and you have a U.S. citizen on the defendant side from State B here. Okay, so we're ready to move on from complete diversity. Again, there are times, the general rule is that each plaintiff is of different citizenship than each defendant. There are times where you have to figure it out, and there are times where they simply tell you the citizenship of the parties. All right, the next element is the amount in controversy. Okay, let's go back to our blueprint here. So, in the blueprint, it tells us our general rule. The amount of controversy is met when the plaintiff's claim seeks more than $75,000 in damages. So you guys know this at this point. You've heard that number a lot at this point of your bar and just legal education. You've heard this, more than $75,000, okay, excluding attorney fees. If the plaintiff is seeking an injunction, the value of the injunction is used to assess the amount of controversy. So they kind of have to give you something, or you just kind of like, you know, based on the circumstances, make something up that's logical. But there's no way or figure that we have or formula for calculating the value of an injunction. All right, so we have three little sub rules here for the amount in controversy. So you had your general rule, and then you had three sub rules. First one is the aggregation rules. First one was the good faith rule. Next is the aggregation rule. And then last is the timing rule. Quick live hypo. This is not in your hypo section. It's just me just giving you guys one quickly. Let's go with Esteban. Esteban, if I were to sue you for $80,000 and then the jury ultimately only awarded me $60,000, which is under the $75,000. Would you say if you then challenge subject matter jurisdiction at the end of that case that you'll be successful?
I'd say yeah, because I think it's based off of like when you filed the actual action, right? So if at the beginning of the lawsuit it was above 75, then that would carry.
Okay, exactly, right? So, but I think I said, would you be successful if you challenge subject matter jurisdiction? So, based off of your logic, you're going to say that you would be unsuccessful in the challenge, right?
So I thought I was the plaintiff. You're the plaintiff?
Oh, yeah, I'm the plaintiff.
Oh, then yeah, okay, then that would make more sense.
Yeah, because the defendant is going to only be the one. Yeah, the plaintiff is never going to want to challenge subject matter jurisdiction, only the defendant. And so there you go. So what you guys want to realize is that that is a trigger for discussing the good faith allegation rule. If on an essay, the plaintiff is ultimately awarded less than 75,000, the defendant might say, well, hey, like this was not a good faith claim for 75. But that's not necessarily the case. If there was good faith that it was more than 75 and it just so happened to be less, then hey, there's no harm, no foul there. However, if the plaintiff at the time of filing the case has no good faith in that their claim is of value to that point of more than 75,000, then that's where you violate this rule. So if I was suing Esteban because he pushed me in the pool while I had my cell phone on me, and then I'm saying I'm suing him for $80,000. There's no good faith that I have that my claim can go to 80,000 for him pushing me in the pool and simply breaking my phone, right? So there, right, I'm not going to be able to get in federal court by just throwing out this large number of damages when I have no good faith in that. Now, if I was in a car accident and I was driving a Lamborghini and he totaled my Lamborghini, well then boom, we know Lamborghinis are very expensive cars, often in the six figures. He totaled that car. In good faith, I thought the damages were going to be more than that amount. Turns out it was like right around 70,000, less than 75, but I had good faith that it was more, okay? So that's all you need there is good faith. Next, you have the aggregation rule. Now, this one's very important. You'll see this one get tested. The aggregation rules are used to essentially add figures, add numbers to satisfy the amount in controversy. Okay? So you have three different aggregation rules. Really go ahead and star the first bullet point and highlight it or whatever you're doing, because that's really the only one tested. And that's where a single plaintiff can add their claims that they have against a single defendant. Okay? A single plaintiff can add their claims they have against a single defendant. We'll see this here in a second, so I'll give an example with the hypo. You also have a single plaintiff against jointly liable defendants, right? So one party suing two defendants who are jointly and severally liable, all right? And then you have the aggregation rule for multiple plaintiffs with a single indivisible injury, which is rare. When you're talking about personal injury, you can never have a shared single indivisible injury with somebody. So really that only comes up with property. And so the example that you might want to look out for is if both plaintiffs jointly owned a car that was damaged by the defendant. There was a single indivisible injury. The jointly owned car was damaged, right? But again, aggregation rule 2 and 3, as I have here in this note, after reviewing all essays on SMJ and reviewing Adaptabar MBE questions, we have not come across any questions testing aggregate rule 2 or 3. So it's just not worth our time to continue on in lecture, but you have those there if you want to read them over. Timing, the amount of controversy is determined at the time the action is filed. All right, Esteban, can you go ahead and read hypo number 5 from diversity? Starts off with Allison and Nicole decide to get egg whites.
All right, Allison and Nicole decide to get egg whites for lunch after class. Allison decides to drive since she just got a brand new Ferrari. On the way there, they are hit by Dante, who was distracted while driving because he was driving and looking at himself in the rearview mirror as he sang the lyrics to Milkshake by Khalees. Allison suffers property damage to the car in the amount of $40,000 and personal injury damages in the amount of $40,000. Nicole suffers personal injury damages in the amount of $40,000. Allison and Nicole each bring a negligence suit against Dante. Allison and Nicole are citizens of California, and Dante is a citizen of New York. Is subject matter jurisdiction satisfied by a federal question or diversity of citizenship?
Okay, so for these questions, you got to go ahead and separate the parties out into separate lawsuits. All right, so you have A versus D, and you have N versus D. Can you tell me, Esteban, what was the citizenship of each party?
Amber or Allison and Nicole are from California, and Dante is from New York.
Perfect. So do we have complete diversity?
Yes.
So that's easy. They gave us the citizenship, right? Each plaintiff is of different citizenship. Even though Allison and Nicole are from the same place, that's okay. You can have two plaintiffs or two defendants from the same place as long as it doesn't conflict with somebody on the other side of the lawsuit. All right? So that's totally fine here. And they're not joint plaintiffs either, the way that we're breaking this down. So really, there's no issue. Now we get to the amount in controversy. What's essentially our issue here? That we do not have one individual claim that is
shared by both of the plaintiffs.
We do not have one individual claim that is more than 75,000, right? There was something around 40,000, another 40,000, and then it was 3 40,000s, right? They're all 40K. Yeah, so personal injury was 40 for Allison, property damage was 40 for Allison, and then personal injury for Nicole was 40,000. But nothing by itself satisfies 75K. So again, now we have to see if we can use the aggregate rule to add up anything to satisfy this. So are any of these parties or both of them going to be able to use an aggregate rule to satisfy the amount in controversy, Esteban?
I believe that Allison should be, her name's Allison, right? Allison should be able to because she can combine the two 40s to make 80, but Nicole won't be able to join in her 40 with Allison's to meet that requirement.
Exactly. What rule are you using for Allison to be able to aggregate her claims?
Is it the first one that we went over, the single plaintiff against single defendant rule?
Exactly. A single plaintiff can add all of their claims they have against a single defendant. And so here, she had personal injury claim for 40 and property damage for 40. You add those up and you get 80. That's more than 75,000. She might be awarded less, but as on these facts, nothing shows bad faith, so we can assume this is in good faith. Now, the question is, can Nicole add Allison's 80 to her 40? And the answer there is no. That's no longer a single plaintiff. That's an additional plaintiff. We cannot use the single plaintiff against jointly liable defendants. That rule simply doesn't apply because we only have one defendant. And then the last rule was you have multiple plaintiffs with a single indivisible injury. Here, Nicole suffered personal injury in 40,000. That's not a single indivisible injury with Allison. So no, she cannot aggregate that. So what's our final conclusion here, Esteban?
Allison will be able to meet subject matter jurisdiction against Dante, but Nicole will not.
Exactly. And just to go back a little bit, Nicole will not be able to satisfy federal question jurisdiction either. Why?
Because the tort law is a state law.
Exactly.
Not a federal law.
And make sure if that was an essay, you'd start off with she's suing here for damages resulting from a car accident. This would be tort law. Does it say if it's negligence or anything like that either? Yeah. So it says a negligence suit. Negligence is tort law is state law. So make sure you start off with the actual claim. And so there you go, guys. Allison would meet both of these elements. However, Nicole would satisfy complete diversity but fail on the amount in controversy. Any questions on that one, Esteban?
No, I'm good. Thank you.
Awesome. All right, so let me go ahead and erase this.
Andrea, I have a question.
Go for it.
If they had filed a joint suit, would the answer be different?
The answer would not be different, and then you would conclude that they need to break it up in order for then at least Allison to be able to have subject matter jurisdiction satisfied. So if they did a joint suit, you would say that there's an issue because they don't have it over that particular claim by Nicole.
So it's each individual claim, not the suit as a whole.
Yes. Jordan?
To rule out the aggregate rule 3, I just looked at it because it says Alice and Nicole each brought a negligence suit. So was the actual trigger?
That's easy for that to be the case too. Yeah, that these aren't even multiple plaintiffs in a joint case. Exactly.
Okay, is that sufficient? Because it's not you were saying the actual trigger was. It says Allison suffers property damage and Nicole suffers personal injury.
Yeah, and I guess I was like focused on that. This is just not even a single indivisible injury, but even before that, again, you're right that this is not multiple plaintiffs in a joint suit. So you can attack it from either side. Cool. All right, so let's go ahead and jump into supplemental jurisdiction. So remember, this is the back door. You don't start with this, but you try this if you could not get through one of the front door options, okay? Supplemental jurisdiction is used to find jurisdiction for a claim that did not did not satisfy federal question or diversity of citizenship. A claim satisfies supplemental jurisdiction if it arises out of the same transaction and occurrence as a claim that has satisfied federal question or diversity jurisdiction. So the concept here is that for supplemental to work, they have to be latching on to another claim that actually has satisfied something through one of the two main front doors. All right? If you don't have something to latch on to, you can't use supplemental. But that's all supplemental is a latch on. The concept is like, all right, well, we're already hearing this one case. Now you're saying that there's this other case that can't satisfy one of these on their own. However, that other case arises out of the same transaction or occurrence as the one that we can hear. So for efficiency purposes, let's just go ahead and hear it all together. All right? So let's get some definitions down as we get into this section. You have the original claim, which is the claim that satisfied federal question or diversity on its own. You have supplemental claim. That's the claim trying to attach to the original claim. And then you have, just supplemental jurisdiction. It can be used for a claim brought by the same plaintiff or a claim brought by a different plaintiff. Okay? Now, we have an exception and the notion that this is discretionary. The exception is if the underlying claim, the original claim, satisfied diversity of citizenship, you cannot use supplemental jurisdiction if it ends up destroying diversity of citizenship. We'll see this here in a hypo in a second. And then the last thing that you need to realize about supplemental jurisdiction is that ultimately and at the end of the day, this is a discretionary rule. It's at the discretion of the courts to grant supplemental jurisdiction. You have a list of factors here that the court will consider. Now, let me tell you guys this. For me as a bar taker, this list of discretionary rules was novel. I had never seen that in law school before. Then when I get to the bar, I think I've only seen one, maybe two essays out of maybe, let's say, like 6 that have tested supplemental jurisdiction. Only 1 or 2 have actually talked about these factors. So this is not something that you have to talk about all the time. But what I want you to do is read through these factors on your own. And at the very least, if you ever have a supplemental jurisdiction analysis on your essay, at least mention that the granting of this rule is at the discretion of the court. All right, but again, typically not, I would say, necessary, mandatory that you then go through all of these factors as well. Okay? So let's go to our hypos. All right, so let's first start off with the hypo that we just did a second ago. So it says same facts from number 5 from the previous section. Do we have supplemental? So let's get grounded with that question again. We said we had Allison versus Dante. She was able to satisfy diversity of citizenship. She's from California. Dante is from New York. You had Nicole, who was unable to satisfy federal question or diversity. But is she dead in the water? No. She can now try to use supplemental jurisdiction. All right, let's go back to Max on this one. Max, where was Nicole a citizen of?
She was California.
She was California as well. Now, what's the magic question that we're looking to see if her claim can now latch on to Allison's?
If it satisfied diversity.
No.
If it was from the same transaction or occurrence.
Exactly, because realize if it satisfied diversity, she doesn't need to latch on to nothing. She's got it on her own. But since she could not satisfy one of these two, she now needs it. And yeah, you look to see if her claim arises out of the same transaction and occurrence as Allison's claim. And is the answer to that here yes or no?
Yes.
Because
they were in the same in the car together, and they were both hit by Dante in it.
exactly. Again, this is efficiency. They are hearing Allison's case because, as we saw, it met diversity of citizenship. Allison's case is dealing with the car accident in which both her and Nicole were inside this car that was hit by Dante. So when you're talking about Nicole's claim, it's of the exact same facts and event and situation. So therefore, it's like, all right, Nicole, even though you weren't able to get diversity of citizenship on your own, let's go ahead and bring you in under supplemental. Like, we're already here. We can hear your case too. All right, that's the concept. But if we said that Allison also failed federal question and diversity, well, then Nicole has nothing to latch onto because you have to latch onto something that made it in under federal question or diversity. Is that clear, Max?
Yes. Yeah.
Awesome. And then now the last thing. Whenever we're doing supplemental jurisdiction, guys, per that exception, we always need to be doing a check to make sure that bringing in now this new party will not destroy citizenship. So Nicole is being added to the plaintiff side or the defendant side?
Plaintiff.
So it's being added to the plaintiff side. Do we have any issues with complete diversity being destroyed here?
No, because they're from the same state.
Exactly.
Nicole and Allison.
It's still each plaintiff is of different citizenship than each defendant. Again, reminder, it's okay if they're the same citizenship if it's on the same side. Now, if we happen to say it was a completely different set of facts, Nicole was in Dante's car and she thinks she was also part of causing the injury. So she has then this claim against Nicole as well, and she brings in that claim under supplemental jurisdiction. And Nicole is from California. Well, then that would destroy, because now you would have a defendant that's from California destroying complete diversity. Or, last variation, if you were to add still Nicole to the plaintiff side, but Nicole happened to be a resident or citizen of New York, well, then now you have a plaintiff from New York and a defendant from New York. Complete diversity is destroyed. So what happens here is that you don't throw out the entire thing. Allison is still good. This just means the supplemental jurisdiction over Nicole's claim is not met. So now Nicole doesn't have federal question, diversity of citizenship, or supplemental jurisdiction. And therefore her claim will not be heard in federal court. Okay? So those are some fact variations to show you how that works. But do realize that even if diversity is destroyed, that does not affect the original claim. That's only then for excluding the supplemental claim. Okay? So you guys can go through number 2. Actually, let's just go ahead and read through number 2 together really quickly. So, Max, let's do this one. I'll read it. A web developer from state B brought suit against his former employer, a state A corporation. So we have web developer from state A versus corporation from state oh, no, mix that up. Yeah. Okay. A corporation in federal court in district court in state B. The web developer had worked at the corporation's headquarters in state B. The complaint asserts that the corporation violated federal employment law and breached the web developer's employment contract. The web developer seeks $50,000 in damages. The corporation files a motion to dismiss, asserting that the court lacks subject matter jurisdiction over the web developer's employment contract claim. Okay? So, we have to go through this. So, what is web developer suing the corporation for?
Federal employment law.
Exactly. The complaint asserts that the corporation violated federal employment law and breached the web developer's employment contract, right? Okay, so are we going to have jurisdiction for this case under federal question or diversity?
Well, you have federal question for the violation of federal employment law.
Exactly. So we really have two claims here. So that was the first thing to see, is that you have your claim of violating federal employment law, and then you have your claim of breach of contract. So your claim for violating the federal employment law is going to be federal question, right? So the claim for the federal law is going to be met original jurisdiction on the basis of federal question. Now, what about for the breach of contract? Breach of contract is not a federal question because contract law is state law. So, to have jurisdiction over that claim, you would need diversity of citizenship. Are these two parties completely diverse?
They are, but the amount of controversy is met.
Exactly, because it's only for $50,000. So, as it stands right now, there's no diversity of citizenship for that claim, and there's no federal question because it's contract state law. So now the only way to hear this claim for the breach of contract is if the court has what?
Supplemental jurisdiction.
Exactly. And do you think this is going to arise out of the same transaction or occurrence?
Yeah, because it has to both do with the employment.
Exactly. So this is close enough for supplemental jurisdiction. Here, you're not even adding a new party for it to destroy diversity. So everything is met and supplemental jurisdiction. So this is an example, guys, of not as often tested, but it can be seen where you're using supplemental jurisdiction for an additional claim. As we saw in the Allison and Nicole hypo, we were using supplemental jurisdiction to bring in a new party. All right, but you can also use supplemental jurisdiction for a claim. Awesome. Any questions on that, Max?
No, I'm good.
Awesome. Any questions, anybody? Yep, Esteban?
So I understand why the amount in controversy is not met, but isn't there also an issue with the diversity of citizenship since the corporation's a state A corporation, the headquarters is in state B, and the web developer is from state B as well?
Let me see what we have here. A web developer is from state B. All right. A state A corporation in federal district court in state B. The web developer has worked at the corporation. Corporation's headquarters in state B as well. Yeah, so I missed that fact. So you have here, C is a citizen of both A and B. So won't change the outcome because we are, like you said, we already said diversity of citizenship wouldn't be met, but it fails both elements. Awesome, good catch. Cool. All right, so that is supplemental jurisdiction. We are done with the two main doors and the one back door to federal court. All right.